Hi everyone, welcome back to Due Process. This is the second part of the topic. We will continue where we left off last time, and we will start with state agencies. Now, next, I want you to start looking and thinking about state agencies. When we talk about state agencies, we are talking about the Department of Public Safety. Now, DPS, as we have famously gotten to know them, they handle emergency management, right? We also know that DPS is the one that conducts driver examinations. And when I spoke earlier about the FBI statistics, well, guess what? The state of Texas collects criminal statistics and crime statistics, so it is DPS's job to collect these statistics and then pass them on to the FBI. DPS also operates regional crime labs so that they can assist local law enforcement. And if you ever travel around the state of Texas, you will see those black and white cars. And this means that Highway Patrol, or DPS, they patrol in mostly rural areas. Although, as a state agency, they have jurisdiction over the entire state. They can patrol any area in the state, not just rural areas. They are more commonly seen on the highways and on rural areas, just for the simple fact that if you live in rural areas, you may not have local law enforcement such as constables or a local police department. The rural areas are more likely to have to depend on a county sheriff and the highway patrol. Of course, I've given you a link to the DPS website so that if you are interested, you can go on there and you can search through the website for information. Be aware that in the state of Texas, you can renew your driver's license or your state issued ID online. You do not always have to go stand in those long lines. Now, another state agency is the Texas Alcoholic Beverage Commission. The TABC is the one that is in charge of regulating the sale and service of alcohol. This means they regulate not just the sale from distributors to bars and restaurants, but from bars and restaurants to you, the consumer. So, if you are ever, not you specifically, but you as a society, if you are ever out and about, be aware that should you drink too much and then go out and get behind the wheel of a car and you hurt somebody, TABC will come back and charge not just the person who served you, but the bar where you were served. They can lose their liquor license and they can be charged as negligent in any crime that is committed due to their service of alcohol. So be aware, when you drink, it is not just you that you are liable to hurt. Now moving forward, we will talk about local agencies. Here we are talking about first the sheriff. Now the sheriff, here in Harris County at least, we have seen those black and white cars also. The sheriff is the major enforcer of the law in the county. They have jurisdiction across the entire county. This means that you will see them within the city limits as well as the unincorporated parts of the city, therefore the county. It is their job to enforce the laws on a countywide basis. Now, the sheriff is an elected official. He is elected, or she can be elected for a 4-year term. The sheriff is also the person that manages the county jail. And they are also able to execute court orders. Of course, being a law enforcement officer and agency, the sheriff is in charge of apprehending violators of state law in the county. So not only can they issue citations for traffic violations, they can show up on people's doors and serve warrants. They can arrest. They have full powers as a peace officer. as a law enforcement officer. Now, at a local level, we also have constables. Now, a constable is a relatively minor county official. They are also an elected official. The constable's term is 4 years. Now, the constables are assigned to specific areas of a county. So in Harris County, we are broken up, I believe, into 7 areas, into 7 precincts that the constables are responsible for. So as you move from one end of Harris County to another, you will see different constables, and you will see that they are listed. If you are happen to pass a constable's car on the highway, you will see that it says Precinct 1 Constable, Precinct 7 Constable, and so forth and so on. And these are elected by the people in their precinct. Now, the city police are, of course, the ones that will bear the greatest burden because they are the first responders to any kind of criminal activity. The city police is the one in charge of the big metropolitan area. Now, a city police chief, especially here in the city of Houston, it is not an elected position. The police chief is appointed by the mayor and city council. Therefore, the chief of police is not always a person from within our city or our jurisdiction. The current police chief, Art Acevedo, used to be the police chief in Austin. So we will do a wide search for police chiefs. Now, the cities and the counties can spend upwards of 30% of their budget for law enforcement. This means the salaries of all law enforcement officials, from the police chief all the way down to the first-year rookie in a car that is patrolling our streets. This means that the cities and counties are spending as much as 30% of their budget. That is a lot of money, and yet it is still not enough money. In an area as large as Harris County and the city of Houston, we are probably about 4,000 police officers short. Now, detecting crime. Many of the crimes go unreported, and this is because individuals believe that the police won't or can't assist, that they cannot help them if a crime is reported. In many instances in our communities, citizens are very mistrustful of authorities, not because of any specific personal interaction that they may have had, but because in the city of Houston and in Harris County we have a large minority and immigrant population. These immigrants and these minorities come from many countries around the world where they have learned a mistrust of authorities. Be aware of that. It is not because they don't want to report it, but it is because this is what they have seen in other countries, that they cannot trust their government officials to work for them. Also, in many instances, be aware that not wanting to report a crime is not because of a mistrust, but because the person who committed the crime is someone you know. It is a friend, it is a relative. So there is that sense of loyalty that we as people have, and we may not want to get our friends and relatives in trouble with the law. Now, when it comes time to gather evidence, the U.S. Constitution prohibits unreasonable searches. This is via the U.S. Constitution's Fourth Amendment. This means that warrants are not always required. Be aware of that, okay? An unreasonable search means, did an officer have a reason to search you, right? Did you do something to indicate that you should be searched? Now, the reasonableness of a search, of course, is going to be determined by the courts. And by this we mean that ultimately, since we have an amendment, searches gathering evidence, somewhere along the way it was questioned, and therefore a case was instigated as to whether evidence that was gathered or searches that were made were reasonable. Ultimately, you'll have the Supreme Court that will have to decide whether a search is reasonable or not. All right then, moving forward, the magistrate, a judge, is usually the one who will determine probable cause. Of course, anything that is obtained illegally without a reasonable search or without a warrant is not going to be allowed in court. Now, when it comes to confessions as evidence, what we're talking about is that anything that was obtained illegally, such as a confession, is considered unconstitutional. As I stated in the previous slide, we are talking about a court case here. And this is a court case that everybody should know. Everybody has probably heard of it at some point. And this is the case of Miranda versus Arizona. I have given you a link if you would like to read about it. But what it boils down to is that if you are arrested, you have the right to remain silent. Because of this, this means that anything you say can be used against the suspect. Of course, as a suspect, if you are being arrested, you have the right to an attorney. Now, this is where I'm going to tell you, if you are arrested and you are innocent, or even if you are not innocent, do not say a word. We have become very used to seeing people on TV and in movies being portrayed as being arrested. Once they're arrested, the investigating officers will tell them that they can make a deal. Now, as I was saying, do not make a deal. You will see people in the movies and TVs, you will see detectives come in and speak to a suspect, and it says, if you confess right here and now, we can make a deal. Be aware that is a myth. The only ones who can make a deal are the district attorney, and even then, they have to get the approval of the judge. Now, formal charges. In a felony, a case will be held over for a grand jury to review evidence. It is the grand jury's responsibility to review evidence, to hear from the district attorney, and to decide whether there is enough evidence for a charge to be made. If there is enough evidence, it is the grand jury's responsibility to issue an indictment if there is sufficient evidence to hold a suspect over for a criminal act. Now, when we speak about crime, of course, we have to speak about arrest. Arrest, in and of itself, is a form of punishment. Here is a link to a news story on a prostitution arrest. Be aware that just being arrested is a form of punishment, especially in today's climate where we have 24-hour news and we have social media constantly bombarding us. Stop and think of how many times TMZ has sent out alerts where a celebrity has been arrested or a celebrity was seen coming out of a club intoxicated. So when you are arrested, it is already considered a form of punishment. Now your picture will be on the news, you will be a news story, your friends and family will know, your job will know. So be aware, arrest is considered a form of punishment. Now magistrates, judges, are the ones who are in charge of issuing arrest warrants. When you have a charge for a crime that someone has committed, if that charge comes after the commission of this crime, then a judge will issue an arrest warrant for the person that is suspected of that crime. Now be aware that police officers can arrest without a warrant if there is probable cause that a crime has been committed and when circumstances do not permit their obtaining a warrant. Now, the issue comes, what is probable cause, right? This is very subjective. Probable cause is if you are caught during the commission of an act, if there is evidence in plain view or in plain sight of a police officer, then that is considered probable cause and they can arrest you. Now, circumstances not permitting them obtaining a warrant would indicate that there is imminent loss of life, that someone is in danger, situations of that type. Now, pretrial activities. This is when the accused is presented before a judge. These are the things that happen prior to you going, or the accused going full on into court. The accused is charged and their basic rights are explained. The suspect is once again reminded of their rights. Of course, the suspect is informed of the right to an examining trial, and an examining trial is something that happens prior to an actual criminal trial, and that would be that the suspect has requested an examining trial, meaning that they are requesting that the evidence be reviewed because the suspect does not feel that there is sufficient evidence for them to have been charged. And of course, bail may be set. Bail does not have to be set. It all depends on the type of crime that the suspect is accused of. Now, pretrial hearings. Prior to an actual full complete trial, the defendant or the suspect will enter a plea. If the plea is guilty, a later hearing is scheduled to set punishment. However, if the defendant pleads not guilty, then the case is placed on the docket for trial. Be aware, when we are talking about a trial, from the time that a defendant is brought before a judge to enter a plea, to the time that the trial is actually ready for trial, it can be anywhere from 1 to 2 years. At pretrial hearings, motions may also be presented to the judge, and some of these motions are for continuance. The lawyers decide that they need more time in order to prepare. There can be motions for suppression of certain evidence if there is an indication that evidence was not gathered correctly or that there is incorrect evidence out there. Then there could be a hearing that is set for suppressing any of this evidence. If the suspect is trying to offer insanity as a possible reason, then there will be a hearing set for that. Or if your case is of such a high profile that you do not believe there would be a fair trial given or undertaken in the original jurisdiction in which the crime was committed, then a change of venue motion can be filed. And this would be something of a high media attention, such as the young man that shot his high school up down in Santa Fe, Texas. His trial would be scheduled for Galveston County, but because of the notoriety and how much it affected the entire community, if the gentleman goes to trial at any point, it will be in Fort Bend County, I believe is the county that had been chosen for the trial. It is these types of cases that would be moved from the original county in which the crime occurred to a different county so that the suspect can get a fair trial. Now, plea bargaining. Be aware that most cases do end in some sort of plea bargaining. Now, plea bargaining is a secret session held with the prosecutor and the defense attorney. It is done in the hopes of saving taxpayer money and court time. Of course, there are pros and cons to plea bargaining, and this is a listing of some. There is no need to know what all the pros and cons are. Just know that there are good and bad reasons for plea bargaining, and that most cases end in plea bargaining. But they have to have a judge's approval once a decision or some sort of bargain has been made. Now, at the time of trial, the accused, the defendant, can decide between a judge or jury verdict. Either the judge will render the verdict or the jury determines a verdict. If the judge determines the verdict, a jury trial will be waived. This means that all of the information will be presented by both the defense attorney and the prosecutor only to the judge. It will then be up to the judge to decide the verdict. Texas law requires that all jurors agree on the verdict in a criminal case. Should the accused decide on a jury verdict, then 12 members will be seated. 12 members from the community will be chosen at random to be the jury. There will be 1 to 2 alternates in case something happens, but if in a criminal case, all 12 of the jurors have to agree on the verdict. Now, the prosecutor, who is the one in charge of prosecuting the case, of presenting the case, is presenting the case for the state because it is the community that has been wronged. So it is up to the prosecutor to prove beyond a reasonable doubt that the accused is guilty. Now, a hung jury exists, and we've heard this term before. A hung jury exists when jurors cannot agree. It just means that they are hung up on the details and cannot come to a unanimous agreement. Once a verdict has been decided, though, it can be either up to the judge or the jury to decide the final sentence. They do not usually take place on the same day. You will have a verdict, and then at a later date, the sentence will be given. Now, post-trial, there are things that can happen after the trial. Now, a person who has been acquitted, meaning they have been found not guilty, cannot be tried again for the same offense. If they are, this is considered double jeopardy. Also, a state cannot appeal a not guilty verdict. Once someone has been found not guilty, that's it. The state, the prosecutors, cannot do anything else. Now, be aware. Okay, now when it comes to the juvenile courts, juvenile proceedings are civil. They are not a criminal matter. The records of juveniles may be sealed from the public with the approval of a juvenile judge. This means that we are hoping that as a juvenile, if something happens and a crime is committed or an offense is committed, that one instance will not harm you. So in certain instances, you can ask that juvenile records be sealed, and therefore as an adult it will not show up on your record. Now, children as young as 14 may be certified to stand trial as adults, but the legal age being an adult is 17 in the state of Texas. Now, here is an opinion piece about changing the age of juvenile courts from 17 to 18. It is just a read for your information, so feel free to click through when you have some time. Now, the Texas Department of Criminal Justice. So we're finally to the jails, right? It is the state's adult correctional facilities. What we are talking about are state jails here. It is up to the state that once you have been charged and found guilty of a crime, that you be punished. So the State Department of Criminal Justice has probation, prison, and parole. Probation means that you will serve no jail time. You will be put on an administrative assignment with a probation officer, meaning that for whatever length of time the judge gave you for your criminal activity, you will have to meet with a probation officer once a month for however long that term is. You will be subject to urine sample testing, blood sample testing. You will have to verify your employment or verify that you are going to school in order to meet the requirements of your probation. This is in lieu of jail, right? However, there are certain crimes that you cannot get probation for, or that you will not be given probation for, and you will end up in prison or in a state jail, depending on the veracity of the crime. Now, parole is that instance after you have served time in prison. You are still subject to the court's supervision, and you will have to then meet with a parole officer. It is like serving probation, but after having been in prison. You are still subject to the terms of the court's release. You will have to find employment. You will have be in need of housing. You will have to check in regularly. You will be subject to testing for drugs and alcohol. It is up to the Department of Criminal Justice and the judges and the courts to set the parameters of all of these, of probation, prison, and parole. When it comes to clemency, though, there is a specific committee that is in charge of this. The Board of Pardons and Paroles makes recommendations to the governor. The governor cannot on his own decide to commute or to pardon or reprieve anybody. It is up to the Board of Pardons and Paroles to make the recommendations to the governor regarding pardons, commutations, or reprieves. So, be aware that the governor cannot act without these recommendations. Of course, a pardon is basically a free get out of jail card. That means that any crime that you have committed, if you are serving a jail sentence or if you have served a jail sentence, a pardon basically wipes all that out. A commutation is we are commuting your sentence from, say, a death sentence to a life in prison sentence. And of course, a reprieve is that last minute action of the governor for a person that is on death row and about to be executed. Now, be aware that jails or prisons are there for a reason. First and foremost, they are there to be a punishment to the person who has committed the crime. For us as a society, they are there to be a deterrence. We are to see jails and realize that we do not want to end up in a jail or a prison, and therefore it will keep us from committing crimes. At the same time, jails and prisons isolate criminal elements, right? The idea is that they are isolated away from the rest of society. Now, this is the tricky one, is rehabilitation. Jails and prisons are supposed to also act as rehabilitation for those people who have committed crimes. You are supposed to learn from your mistakes. However, this does not always work, right? We see that once a person has been to jail or prison, they are more likely than not to commit a crime once they are released. So this is the end of the due diligence process, or the due process topic for Texas government. If you guys have any questions on any of the information that is presented in any of these slides, I know there's a lot of them, please feel free to contact me, send me an email, or reach out to me through the Student Lounge also, and just let me know. Otherwise, I will see you guys next time. Thanks.